Good afternoon, students. We're going to be talking about liberties, and they're very important to you. I hope you will tune in and read all the details. Today, we're going to be talking about protecting constitutional rights. Let's go ahead and read this first section. The Bill of Rights protects American civil liberties and civil rights. In some cases, government may place limits on individual freedoms for the sake of the common good. The Supreme Court has established that many of the provisions of the Bill of Rights limit the actions of states and local governments as well as of the federal government. This particular these pictures are by Norman Rockwell, except for the one up in the right-hand corner. During his fireside chats, President FDR, Franklin Delano Roosevelt, spoke of the freedoms that we enjoy as Americans. And so Norman Rockwell painted these pictures that you see in 1943 when the United States was in the midst of World War II, and to set apart these four freedoms that we as Americans have: the freedom of speech and expression, the freedom to worship God in our own way, the freedom to be from want, and freedom from fear. Very important. Don't take those for granted. They are not freedoms that every country has. So to speak your own mind, these are very important, and we have them because there's the Bill of Rights. Civil liberties, as we're thinking about civil liberties and protecting constitutional rights, we want to be able to define what does it mean to be, what are civil liberties? So your book has this: respecting and protecting civil liberties is among the most important responsibilities of democratic government. The principle behind the Bill of Rights that I want you to notice that government may not restrict freedoms and liberties without good reason is why the United States has long been a symbol of freedom to people around the world. Without these protections, American society would be very different. As you know, we have our Declaration of Independence says that we hold these truths to be self-evident, that all men are created equal, and that they are endowed by their Creator with certain unalienable rights. Among these are life, liberty, and the pursuit of happiness. Well, how is our Constitution, our form of government, going to protect these liberties? Well, after the War for Independence, or actually during the War for Independence, states drew up their own constitutions, and most of them included a Declaration of Rights. At the end of the Articles of Confederation, they weren't working, so they voted on the Constitution. The Constitutional Convention was held in Philadelphia. George Mason, at the end of that convention, proposed including the Bill of Rights along with the Constitution. And the delegates argued back and forth. Most of them said, we don't need a Bill of Rights because the state constitutions, Virginia, Georgia, South Carolina, North Carolina, Maine, or New Hampshire, Connecticut, all these states have their own Bill of Rights. And those Bill of Rights in the states, and along with this Constitution, dividing the power between the federal government and the state governments, and dividing power between the different branches in the federal government, they're enough to protect Americans' rights. And so they voted down adding a Bill of Rights to the Constitution. However, that wasn't enough. George Mason, who helped write the Virginia Declaration of Rights, and he was a delegate to the Constitutional Convention from Virginia. In fact, as you recall, it was George Mason, that had proposed this Bill of Rights to the Constitutional Convention. And when it was voted down, he said, okay, then I'm not signing the Constitution. I'm not going to endorse it. And he walked away. But George Mason was also a delegate to the Virginia Ratification Convention. And he went there and he urged his fellow Virginians to demand a Bill of Rights as a condition for ratifying the Constitution. And that's exactly what they did. Um, that ratification battle, it was very close as to whether or not the Constitution would be ratified. And it wasn't going to happen if there wasn't a Bill of Rights added. And so those who were supporting the Federalists, who were supporting the ratification of the Constitution, promised the Virginia delegates, we will add a Bill of Rights. This gentleman, Thomas Jefferson, was in France at the time, and he was not at the Constitutional Convention, but he wrote to James Madison, who was known as the author of the Constitution. And he said, a Bill of Rights is what the people are entitled to against every government on earth, general or particular, and which no just government should refuse. And so the Bill of Rights came about. As you will recall, in order to win ratification, supporters of the Constitution said, okay, we're going to add a Bill of Rights as soon as the national government is formed. And James Madison was one of the representatives to the first Congress from Virginia, and he drew up 12 proposals which were eventually adopted. 10 of them were adopted as the first 10 amendments to the Constitution, known as the Bill of Rights. These rights are to protect us against the government. The Ninth Amendment states that the listing of the rights in the Constitution did not mean that other rights were denied to the people. In other words, everything that is not listed in the Constitution belongs to the people, is retained by the people, or the 10th Amendment, the states. So if it's not in the Constitution, if it's not enumerated, if it's not listed there, those powers belong to the states or to the individuals. So you have the right to privacy. Not listed in the Constitution, but you have the right to that. Oh well. So let's go ahead. The 10 Amendments, they became part of the Constitution, Bill of Rights. And you recall that in that Constitution, summer of 1787, it was ratified in 1788, and it goes into effect in 1791 with George Washington serving as our first president. And in 1791, the Congress passes, you recall how they go about the business, has to have 2/3 of Congress, of the House and the Senate. They passed these first 10 amendments. They sent them out to the states to be ratified. 3/4 of the states ratified them. These first 10 amendments that became known as the Bill of Rights. Now, it's important that you are able to distinguish between civil liberties and civil rights. Civil liberties are the basic freedoms to think and act that all people have and are protected against government abuse. Civil liberties, you want to be protected against governmental abuse. In other words, we can't tell you what religion to practice. The government can't tell you, can't take away your right to own firearms. These are civil liberties. And they differ a little bit from civil rights. Civil rights are the rights of fair and equal status and treatment and the right to participate in government. This says that the government is going to treat everyone equally. And for instance, the right to petition the government. Regardless of who you are, if you're in the American system, you can petition the government for redress. So that's part of the Bill of Rights too. Initially, both freedoms and rights of slaves and women were severely limited, but you knew that already. In your book, you have the Bill of Rights. You want to know that they are the first 10 amendments to the Constitution and what each of those amendments do. That's right back there in the back of your book. There are some limits on civil liberties and civil rights. The Bill of Rights set a limit on government, what they could do. But people do not have absolute freedom. You can't do everything. The government has a responsibility to protect the common good, that is the general welfare of the people. So there are some limits on individual liberties and rights. when those rights conflict is the role of government. The ideal government is one that limits liberties as little as possible. In fact, we Americans say we want a very limited government. Ronald Reagan would say, as government grows, liberty shrinks. So the government decides what liberties and rights should be limited for the common good. Speech might be limited when it's likely to lead to lawlessness. And you can't stand up and shout fire in a crowded theater. Somebody could get hurt. You're putting people in danger. So your speech is limited. And then the role of the courts. Courts are used to maintain the balance between individual liberties and rights and the common welfare. Who decides? Well, that's up to the courts. And courts cannot initiate. That is, they can't say, well, we need to rule on this. They can only issue rulings for cases brought before them. And as we studied the Supreme Court, you know that the Supreme Court has to wait for a case to be appealed up most of the time. Most civil liberties and civil rights cases have occurred in the 20th and 21st century. They've been brought by folks like the NAACP, National Association for Advancement of Colored People, the ACLU, the American Civil Liberties Union, or MALDEF, the Mexican American Legal Defense Fund. So there have been a lot of court decisions. How about the 14th Amendment? The Bill of Rights originally limited only the federal government, only the top tier of the federal government. States were sovereign in their own sphere. Each did what they wanted to. Maryland did what they wanted to. And each had their own Bill of Rights. However, along came the 14th Amendment, which was ratified in 1868, and it was intended to protect the rights of former slaves from states. And it forbid a state from passing a law that would, quote, deprive any person of life, liberty, or property without due process of law. Due process here means following established and complete legal procedures. And the Supreme Court began to incorporate or merge much of the Bill of Rights into the 14th Amendment, so that through the process called selective incorporation. And you want to be familiar with that. These are some of the cases of incorporation. Chicago, Burlington, and Quincy Railroad. Just it kind of went the other way. The Supreme Court held that the 14th Amendment's due process clause incorporated the 5th Amendment's just compensation, requiring states to give owners fair compensation. Gitlow versus New York State could forbid a man from plotting to overthrow the government. How about free speech? Nah, sorry, but you can't do that. You can't. There's a clear and present danger. We were in World War I. You can't advocate not being part of the draft. Muir versus Minnesota. You want to be familiar with that. Young versus Oregon. Everson versus Board of Education of Union Township. You want to be very up to date on that. But the Supreme Court hasn't incorporated all the rights. For instance, quartering has not been incorporated. Why? Because there's no key to. So they've been selective in what they have incorporated into the Bill of Rights, or how they've incorporated the Bill of Rights. Third or the Seventh Amendment have not been incorporated. These are cases that the court has used to incorporate various freedoms for the states as well. Two very important ones. This one is Everson versus Board of Education. Here's the conclusion for that particular case. And that is a very important case. Make sure you know what happened there. And another one, McDowell versus Chicago, dealing with the Second Amendment. And the Supreme Court incorporates the Second Amendment to the states, saying that Chicago cannot forbid handguns, for instance. And so that's a very important case that you want to be familiar with as well. Well, that's about it for this section 1. Study over your notes, do well, and do well on the quiz. See you tomorrow.